Hello viewers, and welcome to part 3 of our screencast entitled Estate Settlement and Trust Administration in Connecticut. My name is Richard Land. I'm an attorney and a member of a Danbury, Connecticut law firm known as Chipman Mizuko Land in Pennarolla, which we often shorten to Chipman Mizuko. In parts 1 and 2 of this screencast, we covered the job description of the executor and administrator of an estate, including many of the issues the executor and administrator must face. Now, pretend for a moment that you're an executor of a will. You've gone through all the steps we discussed in parts 1 and 2 of this screencast. You filed the probate application with the probate court, and you got yourself appointed as executor. You paid the decedent's debts and took care of the tax obligations. You sold estate assets to raise the cash you needed to satisfy the obligations, and you think that you're pretty much finished with your job and you want to make final distributions to the beneficiaries of the will. At this time, you, as an executor, are in a pretty uncomfortable spot. You think you're done, and you think you've done a good job, but what if any beneficiary disagrees? Do you really want to make final distributions only to find out that a beneficiary thinks you should have done something differently and is making a claim against you? No. Typically, you would want to know with certainty that the interested parties are satisfied with the job you've done, including the compensation that you claim. You want finality before you distribute. Don't forget what estate settlement is. It is the process of resolving conclusively the rights of interested parties in the estate, and you want that final resolution before you distribute. The question is, how do you get that type of finality? The answer is that you get it by disclosing to the beneficiaries what you've done. That's an accounting, and you ask the beneficiaries and the probate court to approve it. In some states, a full accounting in the probate court is not necessary, but even in those states, an executor is probably making a mistake if he makes final distributions before accounting to the beneficiaries and asking for their approval. In Connecticut, a final account in the probate court is required. The whole point of the accounting, keep in mind, is for you as executor to disclose what you've done, and then to ask the court and beneficiaries to approve it. Then you can make your final distributions. When you account, you're basically disclosing how you handled each and every asset listed in the inventory. You're disclosing what asset you sold to raise cash to pay debts and expenses and whether it was sold at a gain or loss. You're disclosing all the income earned by each asset and all the debts, expenses, and taxes you paid. You're disclosing the fee that you claim for your services. And you're reporting on the assets that are on hand for distribution, and you're asking the court to approve your plan for distribution. It sounds simple, but it can be a challenging job, especially if the executor fails to keep good records or commingles his own assets with estate assets. Full accounts can be lengthy and, depending on the estate, can be many pages, the size of a large book. The rules now allow executors to file accounts that are more of a summary of the full account, but that does not mean the executor is relieved from the duty to account for every asset and every payment. It merely means that the accounts filed in the court need not disclose every detail, because what is filed will be a summary of the details, a condensed version of the full account. It will still be necessary for the executor to be able to offer the detail to a beneficiary who requests it. As attorneys who represent beneficiaries, it's not unusual for us to advise our clients, the beneficiaries, to request the details before approving an account instead of relying on the summary.
Let's talk about some of the more significant expenses of estate settlement. First, let's talk about the fees of the probate court. You can see here how the probate court fees are determined. The fee is based on the size of the estate. If an estate has a value of $500,000, the probate court fee is $1,865. Until July 1, 2015, the fee was set at 1/4% of the excess over $500,000 until the fee reached $12,500, where it was capped. That happened when the estate had a value of $4,754,000. So in this column, you see the way it used to be. The fee was and still is $1,865 on the first $500,000. If the estate was greater than $500,000, 1/4% of the excess would be added. So the fee on a $2 million estate would be $5,615. The fee on a $4,754,000 estate would be $12,500, where it was capped. But then budget problems resulted in changes. As of July 1, 2015, the rate that applies to estates larger than $2 million was doubled from 0.25% to 0.5%, and the cap was removed. So here you see the result. The fee on a $2 million estate remains the same, which is $5,615. But after that, things change. The fee on a $4,754,000 estate is no longer the $12,500 cap. Rather, it's now $19,385. The fee on a $6 million estate has doubled to over $25,000. And you see the impact on larger estates, where fees are not just 10 times more, but 40 times more, and when the estate sizes get very large, the fees are more than 100 times more. As you can see here, the fee on a $300 million estate is almost $1.5 million, where under the old rules, the fee would have been $12,500. Keep in mind, the $1.5 million would be on top of any estate taxes that would be due. There is some relief when the decedent is married and assets pass to the surviving spouse. When assets pass to a surviving spouse, the value of the assets passing to the spouse is reduced by 1/2 when determining the probate court fee, so there is a reduction for assets that pass to a spouse. Keep in mind that avoiding probate through a revocable trust, joint ownership, or pay on death or transfer on death accounts will not avoid probate court fees. That's because the probate court fees are based on the size of the estate for estate tax purposes, not just the probate estate. So the estate for this purpose includes not just the probate assets, but also all the non-probate assets that we talked about earlier in Part 1 of this screencast.
Let's turn our attention to executors' fees. If you listen to the first two parts of this screencast, you have a pretty good idea of what an executor is supposed to do and the risks the executor is exposed to. It can be a lot of work. The executor is entitled to reasonable compensation. That's the standard in Connecticut, reasonable compensation, unlike New York, which has a fee schedule set by statute. So, what's reasonable? It will always depend on the specific facts, but there are some objective benchmarks we can point to when advising our executor clients. First, we advise our clients to keep a log of the time they spend performing their duties with a description of the activity. The time and effort involved are always a factor. Also, quite a few years ago, we collected all the information we could on what local banks and trust companies would charge for their services as executor. This table is representative of what we found at the time. The numbers you see here should be considered ballpark numbers, representative but not really the fees of any particular bank or trust company. From information we can gather today, we believe that this continues to be fairly representative. So a bank or a trust company might charge in the ballpark of $20,000 to settle an estate which has a value of $500,000. And a bank's fee for an estate with a value of $1,500,000 might be in the $50,000 ballpark. Banks and trust companies are likely to provide many of the accounting, investment, and tax services in-house, while an individual executor may need to have additional help to provide such services. So the individual's fee might be less. Other benchmarks we look to are statistics that are frequently referred to, presumably compiled by the Probate Court Administrator's Office. We understand that such statistics for Connecticut estates indicate that the average aggregate value of executor, attorney, and accountant's fees range from 4% to 6% of the value of the estate. The probate courts seem to give these averages some weight when scrutinizing fees as part of the final account. The fees for the attorney or law firm will be another significant expense. Fee practices vary among attorneys. Some will state their fee as a percentage of the value of the estate. If the executor is a bank or trust company which does much of the work in-house,
While the attorney may do less, the percentage may be lower. If the executor is an individual who relies on the attorney to do much of the work of an executor, including accounting and tax work as well as the normal legal services, the prevailing rate appears to be in the 3% range. Some attorneys will charge strictly on the basis of time. Often the attorney will be assisted by paralegals whose hourly rates are quite a bit lower than the hourly rates charged by attorneys. Also, hourly rates can be quite different depending on location. The hourly rates of attorneys and paralegals in southern Fairfield County can be quite a bit higher than the hourly rates prevailing in eastern Connecticut, and some attorneys will try to estimate the time it will take to complete the matter and offer a fixed fee on that basis. That's the end of Part 3 of this screencast. Part 4 will discuss trust administration, including the rules that govern trust administration and the trustee's exposure to personal liabilities for activities he engages in as a trustee.